had some other appointments this afternoon, so we'll go ahead and get started. Mary Lee, if you would call the roll, please.
Yes, sir. Representative Kinner.
Here.
Representative Larson.
Here.
Representative Schwartz. Representative Simpson.
Here.
Ooh, wait a minute. There we go. Representative Stith.
Here.
Representative Walters.
Here.
And Mr. Larson, am I leaving this open for the boss when he comes back?
If you would, please.
Sure.
So the first bill up for our consideration today is House Bill 125, simulcasting. Representative Newsom, we're sure glad you're here with us.
Thank you. Thank you, Mr. Vice Chairman. I bring to you today House Bill number 125, which is a repealer of the simulcasting language in the statutes. The statute that we're talking about is 1125-102, number 7 and big C. And you have a handout, and we'll kind of follow along with that. But as you know, times have changed in the horse racing industry. There is no longer a barrier to gambling on horse racing. In fact, you can place bets on live races anytime from your phone after the passage of House Bill 133 this morning. And this 100-mile rule is out of date. When the statute was enacted, there was thought that people wouldn't attend a live horse race if they could bet on simulcasting races at an off-track betting establishment. I don't think that was true then, and I don't think it's true now. Live horse racing is more of a social experience. People go to live horse racing that would not otherwise bet on simulcast races at an off-track betting establishment, and those that prefer to bet on simulcast races have plenty of opportunity to bet online or at an off-track betting establishment. The attendance at live horse races has been increasing year after year. Betting on live horse racing is not the main revenue source supporting horse racing in Wyoming. The revenue from historic horse racing machines is the biggest contributor, not only to subsidizing live racing, but also to local tax revenue. Forcing the closure of certain off-track betting establishments during live races would negatively affect the impact on the racing industry and on local revenue. This particular statute has not been enforced since 2013, when the historic horse racing was approved by the legislature. So if you want to look at your handout, it kind of gives the same information that I just gave you, and then at the bottom it has the actual statute, 1125-102. And then if you turn to page 2 of your handout, this is the data that goes with the horse racing industry in Wyoming. And as you'll see, from the time in 2013 that horse racing became legal and that historic horse racing became legal, you can see the increase in the first the first rows have to do with live racing. And you can see that over the years, the income from live racing has increased from 2014 to 2018 by 7.9%. If you look at the next row, at the next columns, you'll see that denotes the simulcasting. And simulcasting in that same time from 2014 to 2018 has decreased, the revenue has decreased by 11.5%. If you look at historical horse racing, which are the machines in the off-track betting establishments, from 2014 to 2018, that revenue has increased by almost 50%, 49.7%. So as you can see by the data, live horse racing has not been negatively impacted by those off-track betting establishments within 100 miles of the live horse racing venues. In fact, those numbers show an increase. If you turn to the next page, what you'll see is in those counties that have voted to have historic horse racing, you can see the revenue by city and by county. Each of the racetracks that is permitted, currently now Rock Springs and Evanston, they race 16 days. So 16 days is 4.7% of the available days in a year. If you were to close those establishments for those 16 days, there would be a revenue decrease in those cities and in those counties that are within 100 miles of the racetrack. So within Gillette, it would be about a $30,000 decrease in tax revenue and the corresponding $30,000 decrease in Campbell County, given that both Gillette and Campbell County benefit greatly from having off-track betting as well as live horse racing. In Rock Springs, that would be about 25,000 decrease in Rock Springs, about 29,000 decrease in Sweetwater County. And so if this were to be enforced, you would be decreasing those tax revenues that are going to those cities and counties by about 4.7%. And then your next handout is just a map of where live horse racing has historically been in Evanston, in Rock Springs, at Sweetwater Downs, and in Gillette. And you'll notice that that one up at Gillette, the 100-mile circle encompasses Sheridan. So Sheridan, were this to be enforced, Sheridan would not receive any tax revenue for those days, which would be about a $17,000 loss to Sheridan and a $17,000 loss to Sheridan County, because those establishments would be closed for those 16 days when live racing occurs. So with that, I stand for any questions. So that, well, in conclusion, this is a statute that has not been enforced. And so it doesn't seem like it's necessary. And if it were to be enforced, you would see a decrease in tax revenue for those cities and those counties that have historical horse racing, but happen to sit within 100 miles of a live horse racing venue. I stand for any questions.
Thank you, Representative Newsom. Any questions for Representative Newsom? Representative.
Thank you, Mr. Chairman. Just trying to understand what problem we're trying to solve by repealing this.
Well, the main problem is that it hasn't been enforced. And so as you look at a statute that hasn't been enforced, I believe that would be reason enough if it hasn't been used. The other piece is if it were to be enforced, the decreased revenue for our towns and our counties that have historic horse racing, that have off-track betting within that 100-mile radius of live horse racing venues.
Other question? Please. Thank you, Mr. Chairman. Do other states that offer live horse racing as well as simulcast racing have mileage restrictions similar to this, or do you know?
I do not know.
Mr. Chairman.
Please go ahead.
Thank you, Mr. Vice Chairman. Representative, can you remind me, and so it looks like hometown Sheridan there in the county, the dollars are both the same. Are those the same dollars, or is it split in two? I'm trying to understand that.
But I believe that the total amount of dollars goes into a county, and then the county gets half, and then the city split the other half. So you'll notice, for instance, Green River and Evanston, I think, are splitting money. So, and within Natrona County, Casper, Evansville, and Mills split the money, and then Natrona County gets the full amount, the one over $1 million. But that other half, the other $1 million, is split between Casper, Evanston, and Mills. Evansville, I'm sorry, and Mills. And they would not be, they are not affected at all by this unless there were to be live racing in Natrona County.
Any other questions for Representative Newsom? If not, Representative Newsom, please, if you just stay with us,
Sure.
and we'll open up for public comment. Is there anybody that would like to offer public comment? Well, Representative Fortner, we're glad you're here. Please.
Thank you, fellers, committee, chairman. Representative Bill Fortner from Campbell County, House District 52. I'm here to represent my county in this parimutuel horse racing dilemma. We have had some issues there in Campbell County, and I have went over the existing statute that's in place. It's House Bill 25, which refines the mileage and the ultimate decision coming down to the county commissioners. We're happy with that law, and there could be some changes. I think that possibly just going to the county line as far as the 100-mile district, which would open every county up to having their own parimutuel wagering, whether it be chuck wagon races, chariot races, things like that. There is a few things that could maybe be addressed as far as distance goes. 100 miles, it covers a lot of different, several different counties in our area, which I don't think would be really fair to those counties if they wanted to do their own wagering. That's where we stand on it. We're pretty happy with the commissioners making the final decision in our district on parimutuel wagering. We're not open to groups coming in from out of state and running big organized gambling throughout the state, taking up basically the whole state in the process of doing that. So anyways, that's where I stand on it, and thank you folks very much.
Any questions for Representative Fortner? So Representative Fortner, I have one. You just in your opening comments, you said you referenced this dilemma. And so could you just help me understand, and maybe that's what you was referring to in the conclusion of your comments, was a concern about other entities coming in and being in direct competition with what is in place now. But maybe I'm hearing it wrong. So if you could help me understand that just a little better, I'd appreciate it.
We got two different groups. Actually, one of them is based out of the guy that's the headquarters of that's based out of Las Vegas, Nevada. The other group is based out of Chicago. While they have their representatives for those groups live in Wyoming, that money is those organized groups are out of state. We would like to keep that in state. We'd like to keep more money coming to the community out of those organizations. As far as the 100-mile limit, like I say, you know, if I would, and the commissioners would too, in our county would be happy with just going within the county lines, when Campbell County take in Campbell County, Sheridan County take in Sheridan County. That's sort of the dilemma I'm talking about. Thank you, sir.
Yeah, no, that's helpful. Thank you. So a follow-up question for me, because I don't follow this much and I don't know that I can understand it as well as you do. But so if a different entity comes in, does the county continue to get a cut of that simulcast pot, or is there, and I say that because you suggested that we keep it in Wyoming and the funds stay in Wyoming, but the county, regardless of who participates, receives the portion as defined by statute. Is that correct, or have I got it wrong?
That's correct, sir. They'll still receive the same amount unless this current law is redone and amended. The counties will receive the same amount. The organization that's having the races, they'll receive their same percentage, and I believe the city gets a cut of that too. That was the other thing that I was looking at. You know, that the percentages is actually off balance for the counties and the cities. You know, as far as trying to keep money in Wyoming, I think those need to be raised, but we'd have to do a whole new bill, and they're not really up to that. They want to sort of stay with this one here. Like I say, there's some discrepancy in one county taking over another county in the 100-mile rule, or several counties as far as that goes. I don't know if that'd even be constitutional or not, to be honest with you. But that's where we stand. We pretty much like to leave things standing the way they are, but we would be for that 100-mile rule going just to the county lines.
So, so then one final follow-up. We've heard the argument that the rule isn't being enforced currently.
Pardon me?
My understanding is that portion of the statute, that rule, that 100-mile radius is not being enforced currently.
That is true. Actually, what's going on right now is that 100-mile rule is basically from the south end of the state to the north end of the state. So there's no 100-mile rule basically in play right now. They've pretty much eliminated that. Most of the horse racing is going down in Uinta and Sublette counties right now, and they're basically locking up the rest of the state.
Thank you. Committee, any other questions? Thank you, Representative Fortner. We're glad. Welcome to our committee.
Thank you.
Any other public comment?
Vice Chairman Larson, this is Ryan, and I do have Director Moore of the Wyoming Gaming Commission in the waiting room and a number of other hands up, if you'd like me to permit them in now.
Let's go to, we'll take Ms. Erbkite first if we can, Ryan, and then let's go to the commission, please.
Thank you, Mr. Chairman.
Ladies before Gaming Commission.
Well, it takes a minute because I can't get the green light on half the time. Thank you, Mr. Chairman. Lori Erbkite, representing Wyoming Horse Racing. And you will hear from the probably all three of the other horse racing permittees. I believe they're online. But I just wanted to bring out a few points, make some clarifications. We're supporting this bill. There have been two permittees in the state for a number of years, and they had this issue. They overlapped between Rock Springs and Evanston because it's as the crow flies, it's not as the highway goes. And they, in the statute, it says, unless the permittees agree to waive the rule. That's why it's quote unquote not being enforced, because they have always agreed to work together. After 2015, when it was clarified by the Attorney General's office that this was only for the time that the horse race was actually running. So it's not 365 days a year. It's only for the time the races are being run. And that's why we say it's not being enforced. That's kind of a technicality. It's not, because the two operators have agreed. They did the handshake thing and said, no, let's just get along and you can run yours. Excuse me, I'll run mine and we'll be fine. So, and the other clarification I do want to make is the revenue, it depends on where the actual facility, the machines are located. So if the machines are in Mills, which there's a large OTB in Mills, they get 0.5% from those machines. The county gets 0.5%. That's why you see the variation. It depends on where they're located. If you're only in the county, as there is one here in Laramie County that's just outside of city limits or in one of those little pocket things, then the county gets the whole 1% bid. They don't split it. So I just wanted to clarify those things. But my actual comments, we all want to see live horse racing continue to grow and thrive. And yes, currently, the only races being run are in Evanston and Rock Springs. Campbell County has had live racing for the past 5 years. We were not able to run this year because of the COVID situation, and we couldn't get clarification out of the governor's office in time to get up there and get the track ready. And so we had to move our race dates back to the end of the summer and wound up running them all for whatever reason in Rock Springs. And now a third operator has a contract with Campbell County. So we won't be running there. We're going to do all of our races in Sweetwater County. The other permittee owns Wyoming Downs, and so we'll be doing all theirs in Evanston. But we want to see it continue to grow. We do believe, and we are limited because of the number of days that we have good weather in Wyoming. So we want to see it grow. We think there's room for a third operator. There might be a weekend or two that there's going to have to be an overlap, but we think there's room. We also believe that there's room for another operator in the OTBs. And we believe that if we work together as an industry, we can grow this pie bigger for everybody. But all three operators need to invest the time, the money, and the personnel to develop their businesses independently. And I will tell you, our operation is not out of Chicago. Eugene Joyce and his family live here in Wyoming. He is the primary and the principal. He has investors that he went to high school with. That question comes up often, and I'm happy to answer that clearly. Yes, He went to high school in Chicago, and he does have good friends that had some money that has invested with him here. But he is the managing partner and the operator, and has lived in Evanston, has had his wife's family's from Evanston and have been here for years and years. So I wanted to clarify that. As far as this 100-mile radius, so if it was enforced, the OTBs would have to shut down their machines during the time of the live racing. Would these skill games be allowed to continue to operate during those times? Would the lotto be allowed to? Would there possibly be some new machines that could be coming in? Are they still allowed? It's not really equitable anymore. And again, none of those issues were contemplated when that language was added. And that's why we say it's archaic. It has nothing to do with reality anymore. And so, Mr. Chairman, members of the committee, quite frankly, you have a couple options. You can pass the bill and thereby eliminate any further misunderstandings or confusion over the 100-mile rule. And second, you can fail to pass the bill out and the status quo continues. If a third operator comes in and does not agree with the other operators in the area, they will have to shut down. They will lose the revenue that Representative Newsom mentioned, but we'll all carry on. Either way, the third operator has choices as well. If the bill passes, they can commence finding locations and a manufacturer to open their own OTBs to fund their live racing. If the bill fails, their other option is to pursue legal remedies in the courts. And you'll have to ask that question of them. I have no idea. So the final question that I want you to ask yourselves is, should the state of Wyoming be drawing boundaries and erecting fences for any industry? And that's what that 100-mile rule is. It's a fencing issue. So we would hope you would favorably consider the bill, and I appreciate your time. Thank you.
Thank you. Questions, Representative Wall?
Thank you, Mr. Chairman. Ms. Erbekite, do you know of other states that offer live horse racing that also have a mileage restriction? Same question I'd asked the good representative.
Mr. Chairman, and I kind of think there might be one or two, and then they repealed them. But if you ask Mr. Joyce when he gets on, he'll know. He'll have that answer. Thank you.
Okay, Ryan, who we got up first one? Then we'll come back to the. Ryan, who do we have in the waiting room?
Mr. Vice Chair, I've brought in Director Moore for the Wyoming Gaming Commission, and I've got 5 other hands up, which I'll bring in after Director Moore offers his comments.
Okay, we'll come back after Director Moore to the next one you have up, and then we'll probably after that come back here live, okay? Director Moore, welcome.
Mr. Vice Chair, he is in the room, although he did notify me before the meeting started that he was having some technical difficulties. So I've asked him to turn his camera on, and we'll give him another second here to see if it comes on.
We have you. Hi, Charlie. We can see you, but we can't hear you. Looks like you're swearing at Representative Walters to me. Yep.
Vice Chairman Larson, Director Moore just notified me that he's having some issues with his audio.
Okay.
So,
Ryan, let's try and work that out if you can, and then let's take, who else have you got there with the hands up?
Mr. Chairman, I've got a Mr. Lamb, a Mr. Greer, Mr. Shellstad.
Let's take 2 of them.
Great, thanks.
Sorry, Charlie. Okay, Frank, Mr. Lamb, if we could have you, we're probably going to bring you on first if you'd like to make some comments, and we'll ask questions, and then Mr. Greer will take you next, please.
Thank you, Mr. Vice Chairman, members of the commission or committee. My name is Frank Lamb. I'm the Director of Government Affairs at Wyoming Downs. I want to give you a little background on this issue that's before you this afternoon, and I'll be brief because my good representative from Park County kind of told you most of what I was going to tell you. When simulcasting was first passed by the legislature in 1988, I was working for the commission. At the time, the only way to make a legal wager on a horse race in Wyoming was to be at the track. So there were some concerns at that time that by allowing a patron to make a wager at an off-track location that they might not, or they might choose not to go to the racetrack. So we only had one state in the country at the time that was doing the same thing with off-track wagering, and that was New York. And they had, I think, a 50-mile buffer in New York. And I can't be sure of that because they've repealed that so long ago, I couldn't find it when I was trying to research it the other day. So for some reason, and I don't know what the reason was, Wyoming chose 100 miles. And so that's what we have today. There was some confusion, though, even back then as to how that statute was to be interpreted. And so after consulting with the Attorney General's office, it was determined that it would be best to just clarify what the interpretation was by rule. In 1992, when I was director for the Pari-Mutuel Commission, a rule was promulgated and passed to just kind of clarify the commission's interpretation of that statute. And it's interesting to note that many things have changed in the 30+ years since that statute was enacted. We have the internet and live streaming and advanced deposit wagering companies whose job it is to take the wagers for the tracks. And now we've had COVID, which has shown us that tracks can operate very successfully without even any fans in the seats by using this technology. So in short, the problem that this statute was intended to resolve really doesn't exist any longer. I wish I had the answer to Representative Walter's question of how many states have that. I know that New York repealed theirs a long time ago, and there are off-track facilities all around the major tracks in New York. And as far as other ones, I'm not certain. I couldn't speak to that, but I don't think there's very many anymore because everyone's noticed or found out that this is really not the issue any longer. And with that, I take any questions, Mr. Chairman.
Thank you, Mr. Lamb. Committee, any questions? Okay, seeing none. Mr. Greer, welcome.
Thank you, Vice Chair. I'd like to address a lot of the points that have been made here today, but first I'd like to run through the small speech I had drafted here to present to you all today.
Jack, if we could, maybe if you just identify who you are and who you're with, and then take off.
Yes, sir. My name is Jack Greer, and I'm with 307 Horse Racing. We're the new permitted to run live horse racing at Camplex in Campbell County.
Thank you.
Thank you, sir. To start here, everybody, first of all, Wyoming State Statute 1125-102-7C was enacted to create protection for live horse racing and for those investing in operating live racetracks. That is the same today. This 100-mile statute, even with the advancement of technology, internet, all these things that are getting thrown around here today, that statute, what is it is intended to do, the same thing is still pertinent today. The sole intention of the statute and the 100-mile simulcasting restrictions put forth in that statute are to protect live racetracks and live horse racing. That's the first point I would like to make. The policy of the legislature was clear, and that was a recognition of operating a live horse racing in Wyoming needs to be supplemented with simulcasting in order to make the live racetrack sustainable and ultimately profitable. This was done to help promote and incentivize live horse racing. Again, that is the intention of this statute. The 100-mile protection, although not currently being enforced in Wyoming by the other two permittees, was designed to create protection for those investing in live horse racing by ensuring that live racetrack operators could recover revenue from live event operations. Again, that is what the 100-mile simulcast restriction does. It ensures that live racetracks generate enough funds to put on a live race meet. However, the statute has not been enforced in this matter. There's previously been rapid expansion by other operators and HHR simulcast operations. However, there's not been similar expansion of live horse racing. Only upon the recent addition of a new operator, being 307 Horse Racing, in an attempt to clarify and enforce the statute and rule correctly, have the other operators now come forward to delete the 100-mile statute. In reality, the deletion of the 100-mile statute is going to disincentivize new operators from investing in live horse racing, as it ensures no protection for live racetracks. In other words, deleting this statute section serves to protect only the existing operators and their OTB operations. A better solution would be to clarify the 100-mile statute to ensure live horse racing is again incentivized and there's no more gambling being incentivized in Wyoming. To Representative Walter's point, the great state of Kentucky has a 75-mile restriction on simulcasting that is enforced year-round. 75 miles. Kentucky is less than half the size of Wyoming and has almost 8 times the population of people. That is why the state legislature drafted the 100-mile legislation. That is appropriate in Wyoming. Happy to get with Representative Billy Fortner to talk about this, but the 100-mile restriction is completely appropriate in the state of Wyoming, as 75 miles is appropriate in Kentucky, the best horse racing state in the United States, mind you. So I asked the question before I address some more of these points that have been made here previously. What was the legislative's intent and practical applications of the existing statute in question? Is it to promote and protect live horse racing? Or is it now to delete it and promote and protect gambling and OTBs? And now I want to dive into some of the points that have made and look at this thing from a big picture here. Gambling in Wyoming honestly has been brought into Wyoming originally for live horse racing. Originally, simulcasting was the only form of gambling approved to support and protect live horse racing. We then passed HHR machines to support and protect live horse racing. Then has came the skill-based games, then has came the Wyoming lottery. I heard that online sports betting's been passed. You know, this is, again, going back, it's live horse racing is why we have gambling in Wyoming. And the sole reason we have gambling in Wyoming was to protect and support live horse racing. It's a huge industry. Live horse racing is a huge industry, and 307 Horse Racing in Campbell County are looking to expand on that. To this bill's point, nowhere in the state statute that is trying to be deleted today does it mention live race days. To Mrs. Newsom's point, when you're running through the numbers on live race days, that's not the question here. The bill you're proposing deletes the 100-mile statute, and it does not specify days. The 100-mile statute is intended to be enforced year-round. That is what generates the funds to support live racetracks and ultimately boost and support live horse racing. With that, I'll open it up for any questions. Thank you.
Thank you. No, we'll open it up for questions. Representative Stith.
Mr. Chairman, Mr. Greer, in my community, we have a live theater troupe. Our Board of Cooperative Educational Services promotes live theater, and we also have a movie theater in town. If there were a law that said during productions of live theater, the movie theaters have to close within 100 miles of that stage production, would that be a good law in your view? Because it would promote live theater?
Mr. Greer.
Thank you for the question. Yes, I do think it would be a good rule. You have to generate funds in order to put on your live theater. maybe a 100 miles wouldn't be the application, but maybe it's a city block. Maybe it's a town. You have to ensure you're going to generate the funds that you would require to put on that city theater. And that's what this legislation was intended to do.
Further questions, committee? Mr. Greer? Okay, thank you. Mr. Greer, thank you. Appreciate it.
Thank you.
Ryan, I think we'll come back here to the House. Is there anybody that we have present with us in the room that would like to? Mrs. Shaner, welcome.
Thank you, Mr. Chairman, members of the committee. My name is Mary Ann Shaner, and my firm, Hathaway and Coons, along with Matt Kaufman and former Governor Meade, represent 307 Horse Racing. And as Mr. Greer just commented, I think that this issue really came to a head in the past year because 307 Horse Racing enterprise that started with a family out of Campbell County and a Cody, Wyoming individual. They came about because live horse racing in Campbell County was canceled in 2020, and they wanted to see live horse racing in that county. And so they came forward and went through the Gaming Commission process, became licensed before the Wyoming Gaming Commission. And through the licensing process, 307 Horse Racing sought clarification regarding this 100-mile statute, because it is very important for a new operator coming on board that this be properly enforced, because it is important. Live horse racing has been stated, it's unfortunately a losing venture. And back when the legislature approved simulcasting, it was to support the live horse racing events. And so we sought clarification, and ultimately about 3 weeks ago, there was a hearing before the Wyoming Gaming Commission in which we sought to amend the rule that was referenced earlier that says that simulcasting can only occur during a live event. And the Gaming Commission came down with a position that they believe that it only applies during the time of the event. We do disagree with that interpretation, and we think that the best way to solve this issue is to provide clarification in the statute. And we think that a couple of ideas to clarify the statute include, first, that the 100-mile rule should apply during a calendar year. Definition we think that the racetrack premises should be clarified to that permitted premises within the definition or within the 100-mile statute should be defined to be racetrack premises that are permitted on an annual basis. And third, we think that in order to get this 100-mile protection, that you should have to run the minimum number of days as prescribed pursuant to Wyoming Statute Annotated Section 1125-104M. Currently, by regulation, the Wyoming Gaming Commission requires that you run a minimum of 16 days. So we believe that you should be required to run a minimum of 16 days at that specific track in order to have the protection afforded by the 100-mile statute. And I think that it has been stated that since simulcasting was approved, that you did see a significant increase in the number of races from before simulcasting and HHR machines were approved. Because it was a dying industry, that's why the legislature approved it, was to support live horse racing. And so, but what you've seen is that you have seen only an average of 27.5 racing days since HHR machines were approved. You have seen the handles from the OTB increase from 2014 to 2019 from $500,000 to approximately $800 million. You have seen a substantial amount of increase in OTB simulcasting, and you haven't seen a similar in race days. And yes, we are limited in the number of days that are available due to weather, but you still have not seen more race days occurring. You had a few races being run in Casper, a few races being run in Gillette. Now you only have 2 tracks. And so all of the money from the OTBs throughout the rest of the state are going to the 2 tracks, and you're not seeing the live horse racing be increased. So we think that if the statute was properly enforced and is clarified, that you would see more live horse racing days, which is what our client wants to do. Our client wants to run live horse days and have the revenue associated with the OTBs in order to do that. With that, Mr. Chairman, I would stand for any questions. Thank you for your time.
So, Mary Ann, the testimony we heard there is that there's, so the statute says if there's an agreement between operators, right?
Yes, Mr. Chairman.
And you continue to be okay if there's an agreement between operators?
Absolutely.
I guess the fundamental question that I have is, and we've heard it for as long as I've been appropriations, and we've had historic horse racing and live horse racing come before us, was that the intent, the sole reason for having historic horse racing was to preserve and enhance live horse racing. And I kept a straight face when I said that. So do we feel that live horse racing still needs to be protected?
Mr. Chairman, we do. You know, I think that with a third operator coming on board, it's become even more apparent, but I think that it's incredibly important that we ensure that the money associated with the revenues associated with the OTBs are supporting live horse racing.
I think that I don't know if you've set in on some of the previous conversations when we were trying to abscond some of the commission's funds for their general fund, but we heard, I think testimony from the commission was that live horse racing was on pretty solid ground. No, yes?
Mr. Chairman, what I would say is that because of the OTB revenues that support live horse racing have supported it. So again, you know, I think that what we're saying is that there should be protection it should be around the track within 100 miles to have that revenue associated with those OTBs to support the live event.
So does 307 horse racing have historic horse racing sites?
Mr. Chairman, currently we do not. We are running races in 2021 without having OTB locations.
And is that the plan? Just historic horse racing or just live horse racing, those historic sites? So let me understand that. So there are other historic horse racing sites by the other providers, my healthcare terms, providers in that part of the world. So then how, if a new guy comes to town, how does he establish his, you just go into a bar or a facility? I don't know the right way to say all of that. How do you establish historic horse racing? And is that part of the plan? I mean, I'm just trying to, I'm not sure that I'm seeing the full picture here.
Mr. Chairman, and I can certainly get further detailed information on you, but there is a permitting process through the Wyoming Gaming Commission. You also have to obtain county approval for those locations, and it's something that we certainly are interested in doing. You know, I think that there's been a significant number of machines placed within the state by the other 2 operators.
So then what you're saying is if I was an operator and I continued to have new guy comes to town, sets up, gets permission to do live horse racing, and I've been running historic horse racing, now you're going to be able to impose on the number of days that I can run that historic horse racing because you come to town and establish live horse racing. Have I got that accurate?
Mr. Chairman, that is accurate in the way that it's being enforced by the Gaming Commission before the approximate 4 hours during the live horse racing event. And again, I think that it goes back to that we really strongly believe that the intent of the legislature with the 100-mile statute, with HHR machines, is to support the live horse racing facility.
And is the theory, Marianne, is the theory then, again, because this is kind of a foreign subject to me, is the theory then that if I enjoyed historic horse racing and live horse racing, that I would not attend a live horse racing event if I could go to a historic horse racing facility and participate there? Is that the theory?
Yes, Mr. Chairman, to get the patrons to the event, where there's obviously wagering occurring there, but the intent is to encourage folks to attend the live horse racing events.
Thank you. Any other questions? Representative Stith.
Mr. Vice Chairman, for Mrs. Shaner, let me ask you the same question I asked Mr. Greer. I think we'd agree that it would be bad public policy to give live theater troops a veto power over whether movie theaters can be open or not. That'd be bad public policy. So if that would be bad public policy, why is it good public policy to allow live horse racing a veto power over whether, say, historic horse racing places can be open?
Mr. Chairman, Representative Stith, I think that it goes back to the fact that the purpose and intent of the statute was to protect live horse racing. With the theater, troupe, live movie theater, maybe you have the same owner, maybe you don't. But in this case, you have the same owner that's running the OTB locations, that in order to have a simulcasting permit, you have to run a minimum of 16 days. You have to be a licensed permittee that runs live horse race days. So I think that it's a little bit different context between a theater, and again, states like Kentucky have it. And one other point that I would say is that you wouldn't see a loss of revenue, you wouldn't see a loss of jobs, because I think that if the statute is enforced correctly, it brings everybody to the table. And it also, if another operator were to go out, then the permitted racetrack operator would then provide the opportunity with the OTBs. We feel strongly that the OTBs within the 100 miles should support the track.
Any other questions? I didn't know that was such a complex thing to push the button and make sure you're on it. Any other questions for Marianne?
Thank you, Mr. Chairman, members of the committee. Appreciate the time.
Thank you. Ryan, I'd like to see if Director Moore is able to connect with us. I see Director, can you try and unmute and participate with us?
Yes.
I heard you.
Sure. Can you hear me?
We can.
Vice Chairman Larson, again, thank you, and I apologize for the connectivity issues. We got about 12 inches of snow here in Casper, and we lost power at our office this morning, and it's still not up and running. So I'm sitting in my wife's office at the house right now, running on batteries. So again, my name is Charles Moore. I'm the director of the Wyoming Gaming Commission. I'm neither speaking in favor nor against the bill. But if you wouldn't mind, I'd like to give you a little bit of background and some facts that might clarify a lot of what's been discussed here today and answer questions.
Director Moore.
Yes, sir.
Moore. And please, we're on a limited time frame and we've had a lot of history. So if you can avoid history that we've already heard, we'd appreciate that.
Absolutely. Thank you, Vice Chairman Larson. In '87, simulcasting was authorized. Shortly thereafter, they promulgated the rules. And again, Wyoming was one of the first states to authorize that. In reading the statutes and the accompanying rules that go with that, it appears that the purpose was to strictly put butts in the grandstands. And excuse my language, but that's what it was about. In a conversation that I had with commissioners at the time this was being done, they all agreed it was not to limit the off-track wagering locations other than during the time the races were won. We have a supporting Attorney General's opinion that supports the rule and the interpretation. That opinion was in 2015. And, we feel very confident the direction in the interpretation of the statutes. Additionally, offering an opportunity to negotiate alternatives if simulcasting was allowed during the time of an event. It is important to remember that simulcasting in those days was offered by a third-party vendor that did not offer horse racing. It is the live events. It had the potential to enhance and bring more people to the races. The same practice could be rekindled today, having simulcasting at the live events. One of the examples that was used back in the 80s was Evanston, Wyoming, specifically Wyoming Downs. Instead of driving 10 miles to the racetrack, you could go 2 miles to the off-track wagering location. And that was the concern of the permittees. And it was always about the live event, as you have said. To answer Representative Walters's question, are there other states and what other states are doing? Again, in the same vein that we're in, South Dakota speaks about a 50-mile limitation, but it's also conducting a race meet at the time. Michigan is also another state. On that day is their blackout. And I would liken this to the NFL blackout during the games like you can experience in Denver. The companion rule is very clear, stating that the blackout is during the time a live event is being performed within the state, if within 100 miles. Each time this comes up in argument, what the argument is everyone feels like it would be throughout the year and they should be closed. Again, the first time this question came up regarding this statute was in 2014. We had a rule petition of Chapter 10, Section 6K, and the commission heard the request and denied it. And then again, as I said, we had an AG's opinion, which was provided in support of the commission's decision. And again, more recently, as noted here briefly, on November 12th of this year, 307 Horse Racing submitted a question and questioned the validity of Chapter 10, Section 6K. And then and we responded to that in a letter from the Attorney General's office, which was dated shortly after the November 12th letter. Pursuant to, we also, have had a rule petition, which we dealt with here February 19th, and we again denied the request to delete the rule. And just citing the motion that we had at the February meeting, I think it's important. A lengthy discussion ensued, including comments from the following permittees: 307 Horse Racing, Wyoming Downs, Wyoming Horse Racing. Additionally, public comment was received from the horsemen and other interested parties. At the conclusion of the discussion, after receiving all public comments, a motion was made by Commissioner Leinen, seconded by Commissioner Curra, to deny the request for the following reasons. The commission feels the current interpretation is accurate. The rule is consistent with Wyoming statute and agrees with the Attorney General's informal opinion dated January 7th, 2015. Any deviation from the current practices would require legislative change. Therefore, our 34-year practice is in accordance with the law, and we deny the request. I hope that information helps you and brings some clarity, and I do stand for questions.
Thank you, Director Moore. Committee, any questions for Director Moore? Okay. I think, Ryan, while we still have the screen up, we'll maybe see if Mrs., is it Faber or Faber, if you'd like to join us.
Thank you. Yes, I'm Commissioner, Campbell County Commissioner Colleen Faber. Mr. Chairman and representatives of the House Appropriations Committee, I appreciate your time today. We'll try to hit different points a little bit. First of all, strongly opposed.
Colleen,
Yes.
could you just share with us who you represent, or are you just on your own, or?
Campbell County, sorry.
Thank you.
And I have another fellow commissioner, he'll probably follow up for me, so anything I miss, but I want to just let you all know that we in Campbell County are here, and I'm also an AQHA Life member. So I really have dug into this. This all started back in 2013. And I did provide the committee with a brief that we were provided with, not me specifically, our commission, our county commission back in 2013, which specifically identified why House Bill 25 was put forth by Representative Wallace and Senator Schiffer. And it was specifically to support live horse racing. At the time, we were able to put at the time they put that forth, there were only 25 race-bred Wyoming bred race horses in the state. And just to kind of touch on a little bit about talking about, do we shut other places down for other things? This is an industry in our state. It's a high dollar industry that's being put out of business and was at the time by casinos and gambling facilities and things like that. So it was for protection of live horse racing. Where have we come? I don't know how many more race-bred horses, but we do have some. A University of Wyoming study done in 1999 on the Evanston track showed $6.6 million in the economy from that horse racing in just at that track, along with 232 part and full-time jobs. That's something Campbell County could really use right now. What we get right now is a 0.5% comes to, it's been a lot more the last couple of years because the gambling facilities, again, are becoming more popular. Somewhere in the terms of 200, 250,000. Sheridan County, I did talk with a commissioner there, I think 160 some thousand. And I know Representative Kinner is on that, is on your committee. I would just like to tell you, Representative Kinner, in 2018, likely due to the increase in revenue for live horse racing in our state because of House Bill 25, the two top money earners in the racing, Wyoming bred racing in our state were from Sheridan County. And they accumulated over $300,000 in earnings in your county to themselves, where your county got very little in those funds. That's from live horse racing, two entities. There were 49 Wyoming bred awardees that year. And this is from the AQHA, American Quarter Horse Association. I would implore you that the 100 miles around the Camplex racetrack, because it is the only, I think the only racetrack in that diameter is Sheridan's racetrack, and will support your industry of horse racing, where you have several entities, and we do in Campbell County, as well as draw from Montana, South Dakota for the multitude of different races that will be held at Camplex. We welcome live horse racing. The revenue is much greater than the gambling facilities, which I don't know a lot about. I haven't even been there, but have had to deal with how we've permitted those with the caveat that we're getting live horse racing. And right now, over $50 million is being run through those facilities. We're getting about 250,000. The rest is going to support live horse racing, not in our county last year or this year. And we wanted live horse racing in 2020, and we were ready with a plan. We actually also tried to get the National High School Finals at Camplex. Campbell County made it work, and we could have had live horse racing, but the entity chose not to. And we have an entity now. The facilities, the off-track betting facilities, they are to support live horse racing. That's how the model was set up. We need to understand how we're going to make that work in those 100-mile quadrants of our state so we can have live horse racing and draw from different geographical areas, because it's a lot bigger industry than a lot bigger revenue for our county than our facilities. And we're fully supportive of helping you formulate how that looks. I've been talking to Speaker Barlow as well, and many of our representatives, but I really want to implore you that this is for an industry that's very large, and while Wyoming's ag industry is huge, the horse industry is also huge, and we want to try to grow that. We're at a time where I see the legislature looking at where are we getting revenue. This is where. However, we have got to promote it, and it's expensive. I have horses. You could ask my husband. They're expensive. Horse racing is an expensive endeavor. However, the returns are wonderful for our revenue in our state. And I just want to speak to oppose this, and I would implore you to look at what we're missing out on and how it can work. And I have already given the Gaming Commission comment before. I've been in to several of their meetings, trying to really get up to speed on how we make this work for our state, because it's a great industry. And the 100-mile rule is in place for a reason, and it does have validity. There's been a lot of discussion on when and how long. It will come down to our county, and we do have a lot of authority over these entities that operate in the county. But I really do believe legislatively, we need to look at how we're going to support this industry, because it's a great revenue stream and it's a great industry. I'd really like to support it. And so I would stand for any questions if you have any.
Committee, any questions? Mr. Shellstat, you're up next.
Okay, thank you,
and
Mr. Vice Chair and
Shellstat,
Committee. Can you hear me?
We can, and if we could please keep it brief.
Absolutely, Mr. Vice Chair. I understand you're under a time hack and you got to get back to session. I will keep this brief, and no pun intended, but I don't want to beat a dead horse. So number one, I guess we've been asking Mr. Moore from the Wyoming Gaming Commission to come to Campbell County or get on a Zoom meeting with us and educate us on this subject. Because we haven't even heard back from them on this, we've chose to educate ourselves. And you know, one of the things that's been brought up several times in comments is this rule, this 100-mile rule, has not even been enforced. And I think my answer to that is because there's only 2 operators right now that have chosen to collaborate together. They're not needing to enforce it because they're collaborating. And I guess our opinion is that when 307 came to us and said they had a desire to be an operator, and they subsequently became the 3rd operator, now it seems to me like the collaboration effort of the other 2 OTB companies is now this piece of legislation. And it just bothers me that we can't keep a rule that's in place to protect the live horse racing, which is what we desire in Campbell County, and to force those people to have to collaborate with one another to operate. And Mr. Vice Chair, I guess our only option at the end of this, if this legislation is to pass, is to pull the permits of the 2 OTBs in our county. And we don't want to do that. We want to see them work together, but we want to promote live horse racing at our facility in Gillette. And I stand opposed to this bill, and I stand for any questions. I hope that was quick enough.
Perfect. Thank you. It's appreciated. Questions for Mr. Shellstat? Commissioner Shellstat, thank you.
Thank you.
We're back here in the room. Is there any other public comment?
Vice Chairman Larson, I do have Eugene Joyce with their hand up, and then Mr. Greer has also raised his hand up again.
We've heard from Mr. Greer. We'll hear from Mr. Joyce.
Bringing him in now, Mr. Vice Chair.
Can you hear me?
We can. Mr. Joyce, please join us. Please identify yourself and share with us who you are and who you're with.
Right. Thank you, Mr. Vice Chairman. Eugene Joyce with Wyoming Horse Racing LLC, and I speak today in favor of House Bill 125. The bill simply repeals a section of the statute that has recently caused a tremendous amount of turmoil within the horse racing industry. At present, the 100-mile language in statute is being construed by certain parties in a novel way that, if allowed to be pursued through the courts, could have devastating consequences for our industry. However well-intentioned, that vision for our industry would weaponize this part of the statute to allow one private business to have autocratic control over the business activities of their competitors in a described geographic area, ostensibly holding the other private businesses hostage for ransom year-round. At best, it's fencing out competition, and I would say at worst, it's claim jumping. Now, all of the stakeholder groups in our industry have spoken out against this plan, and yet certain parties persist in a belief that they know what's best for our industry. I admire their tenacity, but I would tell you that does not make them right. The next logical path forward for those favoring a reordering of how our industry conducts business is a legal one. The truth is, our industry is poised for a breakout growth in 2021. Yet legal posturing regarding the reference of the 100-mile limit has put a chill on future investments. Bankers, investors, and lawyers are wary to okay investments for future growth when the remotest risk that overnight you might lose 35 to 50% of your revenue. All businesses want some modicum of certainty that they won't be put out of business after investing their hard-earned capital. Opportunistic litigation will always hang over this industry and wasting a lot of the state's time and money if the 100-mile language is not removed from statute. The current economic model for the horse racing industry in Wyoming has fostered competition, which in turn has grown the revenues to the cities and counties where we operate. Competition has grown purse monies for the horsemen. Competition has created dramatic growth in our breeding industry, and competition has allowed horse racing, which was literally dead 10 years ago, to grow into an industry that has, of 2018, an economic impact of over $65 million to Wyoming. This misguided vision of creating fences in our industry comes from what I believe to be a scarcity mentality that the market is saturated with no more room for growth, so that the pie has to be carved up differently in order for a new permittee to be profitable, when in fact, the opposite is true. Our industry welcomes competition, but the bar to entry is an expensive one. 16 days of live horse racing can cost up to $2 million. Opening OTBs costs millions and millions of dollars more. Weaponizing this part of the statute would allow someone to not spend a dime on OTBs. They merely have to force the current operators to pay them a tribute to operate within their sphere of influence. It's actually quite a brilliant business plan, but who does it benefit? It benefits one party and it doesn't create one extra job. It doesn't grow the revenues for the cities and counties or for the state or for the horsemen. The competition that is an integral part of the present economic model of horse racing does all of those things. Fencing out competition does not. We welcome anyone who wants to join our industry. All we ask is that they roll up their sleeves and have their efforts be additive to what has been an unqualified success story nationally for horse racing and for the state of Wyoming. This bill will settle these issues for good so we can all work together to do what's best for the stakeholders in our industry, which in turn benefits us all. With that, Mr. Chairman, I urge the committee members to vote for this bill as presented, and I'm happy to stand for any questions from the committee. Thank you.
Thank you, Mr. Joyce. Any questions from the committee? Okay. We're back here at the Capitol. Are we good here on public comment? We'll let you wind it up, Representative Newsom. Okay, we're going to close public comment. And Representative Newsom, we'd like to bring it back to you before we address the committee.
Thank you. Thank you, Mr. Chairman. I would just like to speak to the purported lack of support for the industry. If you look at the second page on your handout, you'll see the bottom, the combined total breeders award, and that's the money that goes back to the horsemen. That's the money that supports live horse racing in Wyoming, and that's the money that supports the breeders. And that has grown year over year from 2014 to 2018. That amount grew by 46.4%. And looking at my newest numbers in 2019, that number went to about 3.2 million. That is going back to the horsemen. That is in support of live horse racing and the breeding of horses in Wyoming. And with that, I will conclude since we're having so much fun here.
Mr. Chairman.
Committee, any final questions for Representative Newsom? Representative Simpson.
No, I wanted to.
Okay.
You're going to learn something new about me today. While you big tough guys were playing football in high school, my little 135-pound frame was at the racetrack, pony and horse races. So I want you to know I'm really, really prejudiced on this one. I am for the horse racing industry. I remind the committee that in order to wager on horse races, there has to be a horse race. And so I'm going to be against this. Thank you.
Question to Representative Walters. We want to know the answer to that. Go ahead, ask him again.
I was never brave enough to be a jockey. I only ponied the horses.
Okay. Committee, what's your pleasure?
Second.
Move the bill and second. Okay. We have it here in front of us. It's pretty, I don't know how you can get much simpler. You repeal language or you keep language. Any comments on the bill? Okay. Question on the bill?
Representative Kinner,
Get my speaker turned on here. No.
Representative Schwartz,
Aye.
Representative Simpson,
No.
Representative Stith,
Aye.
Representative Walters,
No.
Chairman Nicholas. And Vice Chairman Larson.
Aye.
So we have 4 ayes and 3 noes.
Thank you. Come on up, Mr. Frank. Please proceed.
Thank you, Mr. Chairman, members of the House Appropriations Committee. I'm here today on behalf of the University of Wyoming. I'm a registered lobbyist for them with regard to this bill, House Bill 198. And I would just, if I can, Mr. Chairman, can I walk through?
Handout?
Okay, thank you. Years ago, the city of Laramie and the University of Wyoming agreed that University of Wyoming would pay all maintenance and operation expenses and construction costs to run the Jacoby Golf Course. City agreed that they would provide free irrigation water for that golf course. And the trade-off was that the UW then and still operates it as a municipal golf course available to anyone who wants to play there. Over the years, the city changed their mind and began charging UW for irrigation water that they were supplying. And then over the years, that cost to purchase irrigation water from the city has grown exponentially. Eventually, the University of Wyoming Board of Trustees decided to try and control those costs, and they originally came to the legislature and obtained funding for the Wyoming Water Development Commission to drill a well on UW-owned land near Jacoby. And unfortunately, that well didn't work out. It did not produce enough water that it could be further developed. Subsequent to that, University of Wyoming trustees and the board purchased land near Jacoby to establish a common ownership of that land around the golf course, and also to try and find water to irrigate both Jacoby and the campus. Ultimately, they received permission from the state engineer. They drilled 2 wells, and those wells actually found abundant water. In that part of the world, there's a thing called the North Platte River Settlement, and then there's a thing called the PRIP, Platte River Implementation Plan. Those 2 agreements that the state entered into long ago, I think in 2000 maybe or so, limit the amount of water that can be produced from groundwater sources like these 2 wells. So ultimately, the state engineer intervened, and the University of Wyoming agreed that even though these 2 wells could produce far in excess of 540 acre feet per year, that we would limit our production and limit the permit to that amount. Ultimately, that permit was issued this fall. And so we have 2 permitted wells that allow us to produce 540 acre feet per year for irrigation, both at Jacoby and the campus. Laramie, the city of Laramie, has been interfering with that process for several years. And the kind of final straw that makes this bill, House Bill 198, so important was on August 4th, 2020, Laramie passed an ordinance that basically says that UW and private citizens too, but it was aimed at the University of Wyoming, cannot import any water into Laramie city limits. Nor could University of Wyoming, if they needed to, use the streets, alleys, or byways to build the infrastructure necessary to bring that permitted water to within the corporate limits of the city of Laramie. On behalf of the University of Wyoming, we believe that far exceeds any statutory authority that the legislature has granted to a municipality like the city of Laramie. And we believe ultimately, if necessary, we would win if there were a lawsuit challenging the existence of that ordinance. The University of Wyoming is what I would characterize as a super kind of state agency. They derive their power, and the Board of Trustees derive their power from the Wyoming Constitution and various statutes passed over the year. They have greater authority and greater dominion over their affairs than I believe many other state agencies have, and certainly far superior to cities, towns, and counties. You know, the cities, towns, and counties hate to hear when people say this, but the Supreme Court has said it a number of times that cities, towns, and counties are creatures of the Wyoming State Legislature. And the legislature has never granted a city the authority to prohibit the importation of water or the use of water within their city limits. In the state of Wyoming, all water belongs to the state and is under the control and jurisdiction of the Wyoming State Engineer. We've gone through the state engineer, we've obtained the permit. State engineer has now issued that permit. We need to put that water, the 540 acre feet per year that we can produce, to beneficial use. And then the State Board of Control will give us an adjudication for that amount going forward. The city's ordinance is just unconstitutional and illegal. House Bill 198 basically says that UW, what I believe is already in existence in the law, but it says the University of Wyoming and the University of Wyoming Board of Trustees have the power and authority to regulate the lands and the properties that have been entrusted to their care, including issues regarding water and to irrigate Jacoby and the campus. Basically, it doesn't name them by name. But it also, on page 2 of the bill, starting at line 18, says, and it's, so the first part of the bill, pages 1 and 2, or 1 through page 1, and then page 2 through line 13, create a new statutory authority, just stating what the University of Wyoming's authority is over water. And then on commencing on page 2 at line 18, and the balance of that page, it addresses the city statutes in Title 15. And the reason that is necessary in this bill is that the city of Laramie has claimed that they have the statutory authority under this franchise ordinance in Title 15, which says a city may grant franchises to certain people to provide public services. And most cities have done that, you know, with regard to utilities and gas and electricity. But there's nothing in that Title 15 that we believe gives the city authority to prohibit the importation of water by a sovereign state entity like the University of Wyoming. So page 2, line 18 on, just makes it clear that nothing in the ordinances, in the statutes governing cities, give them the ability to affect the rights of the University of Wyoming as set forth in newly created 2117-126. I'd be happy to answer any questions that the committee may have.
Representative Larson.
Mr. Crank, so I just want to make clear so that the property that they bought where they drilled the wells was not solely for the wells, but am I accurate then in saying that that's outside the city limits? And then if that's correct, I'm kind of curious as why the city hasn't incorporated it.
Mr. Chairman and Representative Larson, the property we bought was outside of the city limits, and I do not know the answer as to why either the University of Wyoming or the city of Laramie has not yet sought to incorporate that. But I will tell you, Representative Larson, that that does not solve the problem because, the ordinance that was passed by the city of Laramie would prohibit us from drilling a well within the city limits and using that water as well. It's a very all-encompassing city ordinance that attempts to totally control both the University of Wyoming as well as private citizens within the corporate city limits from drilling or using water.
Representative Stiff.
Mr. Chairman, Mr. Crank, thank you so much. On page 2, line 2 of the bill, my question is this. If you delete the words potable or, how much grief does that cause you? Does that disrupt the university's plans, or is that okay?
Mr. Chairman and Representative Stith, it does not disrupt our current plans. A city, I will admit that I think a city has some statutory authority to safeguard their potable water drinking system. And I see other cities have passed ordinances saying, if you have a private well in your backyard, you have to get our permission to hook that private well to our city potable water system. And that's obvious, I think. If the private well becomes polluted or has bacteria in it, you could run the risk of polluting the entire municipality's water system. This water will all be non-potable. It'll be produced from our wells. We're in the process of developing the infrastructure to get it from the well location to the Jacoby Golf Course in the campus. But if potable was struck from this bill, it does not cause us grief as far as the University of Wyoming.
Further questions? Representative Schwartz.
Thank you, Mr. Chair. So, Mr. Crank, I heard you say that the city doesn't have the authority to restrict the university. I just want to make clear, you also think they don't have the right to restrict any entity in this respect, and not just the university.
Mr. Chairman and Representative Schwartz, that's a tough question, and maybe I should take a pass on it. I think let me give you an example. If a private landowner already has a private well, and they've been using it for years, this ordinance requires them they're grandfathered, and so they can continue to use it, but they have to install a meter. If I were that private landowner, I'd say, you have no authority to do that. I mean, you're taking a vested property interest I have in this well on my private property. But, any entity that goes too far, I haven't thought about that. I can tell you that University of Wyoming and the Board of Trustees are, like I said, in my mind, a super state agency that has very broad authorities to manage the university, the grounds, the buildings, and the water source to those grounds and buildings.
Thank you. That was the distinction. I just want to be sure I understood you.
Further questions? Go ahead.
Mr. Chairman.
You have 12 minutes.
Okay, I'll make it brief. Would this statute cause the city of Laramie to be in default of any bond conditions that you're aware of? Because I know in my community, if the water utility allows anyone to produce or buy water for their purposes inside the city limits, it violates a whole bunch of bond conditions.
Mr. Chairman and Representative Stith, I honestly don't know. I have attended numerous meetings with the city of Laramie and their water consultants and the city manager. I've never heard that. But it would be odd to me that would be, a city only has such jurisdiction as is given to them by statutes or the Wyoming Constitution. And if a city has no authority to regulate the importation of water, I don't know how that could violate a bond condition, but that'd be my thoughts.
Further questions? Okay, thank you, Mr. Crank. Any public comment?
Mr. Chairman, I have Laramie City Mayor Paul Weaver and Aaron O'Doherty who have raised their hands. I'll bring in the mayor first.
Okay, bring them in. Welcome. Come on in, Mr. Weaver.
Thank you, Mr. Chairman. Very much appreciative of the opportunity to be here with you today. I'm Paul Weaver. I'm a member of the Laramie City Council, currently serving as the mayor of the city of Laramie. And want to thank you again for the committee's flexibility in terms of video attendance at this meeting. So we're very grateful to be here. You may not be surprised, Mr. Chairman, members of the committee, that the city of Laramie has a number of concerns about this bill. And we want to share a few of those with you. We have some concerns regarding its impact to our infrastructure, both physical and fiscal in nature. We have some concerns surrounding the level of investment that both our local government and the state has already placed in our local water system, and that this could represent a potential second layer of expenses for our ratepayers. And we are uncertain that they would be supportive of that. This is controversial with our residents. I can share that with you. And we feel that we're obligated to make sure those concerns are represented to you. Another concern is that this seems to be a peculiar approach that impacts our city's local control authority over water infrastructure, and it raises some questions around language in the state constitution, we believe. That's certainly not an expert opinion from me, but simply some information I'm sharing with you that we've received from some of our own council. And I know that there's going to be a lot of questions about some of these points that I've raised just quickly, and we want to be here to do a good job of answering those. And to that point, Mr. Chairman, there are several people from the city of Laramie attending the meeting today that can very likely provide the committee with more precise answers than I can. I'm unsure, Mr. Chairman, of how you would like us to do that, but we're certainly available for the committee and your questions. And we'd look to guidance from you for how you'd like us to proceed with that. One final point I want to make before we get to that is to emphasize that we are and have been committed to a productive partnership with the university on this issue and really any others. And we're certainly very proud to be the host city for our state's university. Many of us, as you might imagine, are graduates of that institution and supporters of the Pokes, and we're friends. We are friends. We have a good working relationship with the university and the city of Laramie, but like most friends, we occasionally have some disagreements at times. And we think there are probably ways to resolve those issues between the two agencies. And we stand by the ordinance that we passed, but we certainly feel like there are opportunities for us to resolve this issue in a fashion that meets everybody's needs. And that's all I would share, Mr. Chairman, other than to once again provide you with an opportunity to ask people from our city staff that are going to be able to give you better answers perhaps than I could on any specific questions that you might have.
Questions for Mayor Weaver? I don't see any questions. If you have any staff members that want to comment, why don't you bring them in?
All right.
Mr. Chairman, I just admitted Laramie City Manager, and I've got Aaron O'Doherty on deck.
Okay, let's go quick. We've got about 9 minutes. If we can't finish your comments, we'll probably do it on adjournment. We may go very late tonight, and if we do that, we'll have to finish up tomorrow. So, but we want to hear from you.
Thank you, Mr. Chairman. That's very well understood. And I think the city manager is here on your screen, Mr. Chairman.
Welcome.
Good morning, and I appreciate the opportunity to be before you this morning. I just thought it might be important to address a couple of clarification points based on the information you've heard thus far this morning. To my knowledge, the city has never had an agreement to maintain and operate Jacoby Golf Course. We have, however, had an agreement for decades with the university to provide them water. Most recently in 2006, the city council determined to implement a small fee for that water. The discount provided is, I believe, 72% off of the standard and going rate. It is a true statement that the university's costs to irrigate Jacoby have gone up, but I think it's important for you all to understand that the rate that is paid to irrigate at Jacoby is well below what is charged to our domestic users in homes. And that part of the reason the rate has gone up, or excuse me, part of the reason what they paid have gone up is because they're consuming, in fact, more water, greening that turf to attract more collegiate activities and amateur tournaments. So while their cost has gone up, the city is certainly not the only party involved in that. I would offer as well, I've been engaged in meetings for 5 years representing the city over the course of various mayors and councils along with the city attorney, wherein we've offered dozens of solutions to this problem that would be collaborative and mutually beneficial, both for the university system and for the city system, owned and operated, and of course paid for by our residents. All of those solutions, as the mayor said, remain on the table. And despite offering solutions, we've yet to get any indication as to whether the university would like to partner to proceed forward with one of those in a way that would be mutually beneficial. The last thing I will note is that the removal of non-potable water from the removal of potable water from this particular ordinance certainly would pose less concerns for the city as the operator of this system, but it is important and shouldn't be lost in this conversation that even irrigation water or non-potable waters are required by the city to be received into our storm drain and our sanitary sewer systems. So I don't want to lose the connection between water systems, sanitary sewer systems, and stormwater systems. We need to also be able to partner with the university to work on storm drainage and sanitary sewer. So that is helpful, but it still is concerning from the standpoint of operating these critical infrastructure assets. Thank you. If you have any other questions, happy to answer them.
Questions? The city manager. Okay, thank you. Appreciate your comments. Anybody else, real quick?
Chairman Nicholas, I've admitted Aaron O'Doherty.
Okay.
Good afternoon. Thank you for listening to us.
You bet. Thank you. Go ahead.
I'm Erin O'Doherty. I serve on the city council. I urge you to vote against this bill. Let me preface by saying that former Senator Nicholas warned our city council that there'd be retribution from the legislature if we took steps to protect our water supply and our utility. And I've got to tell you, this bill really appears to deliver on that retribution, because at first it was just about irrigation and now it's potable water to buildings. And I feel like there's a feeling that there's just limitless water from the Casper Aquifer. We know that's not true. From drought years, it's drawn down. Also, I urge you to Google the term cone of depression as it relates to hydrology. When a well is pumped next to another well, a cone is created that changes the water table. And so by having a well near ours that's deeper, it could draw water from our well and make it more difficult for us to serve Laramie, even if we could afford the infrastructure without the university. And I'll leave the rest to the professionals. Thank you.
Okay, any questions for her? Seeing none. Any other public comment? Anyone else you would like to have? Mayor?
No, thank you, Mr. Chairman. We appreciate the opportunity to provide you with some testimony and voice some concerns.
Okay, we appreciate it. We've got one more, folks. So go ahead, please. Introduce yourself.
Yes, thank you, Mr. Chairman. For the record, David Fraser, Executive Director, Wyoming Association of Municipalities. I appreciate the committee's time, and I also appreciate that really probably a sufficient amount of time hasn't been dedicated to the myriad of issues that are present here. Particularly, of course, I'm speaking from the city's side, and I would, in so much as talks seem to be ongoing, I guess my encouragement would be that the city appears willing to continue those discussions, and I would ask that the committee encourage the university, its super agency, to continue those discussions and to see if they can reach before we result to a legislative solution, to see if we can work out something mutually agreeable to the parties.
Okay, any questions?
So, Mr. Chairman, just one quick one. So I think we've been in this discussion since about 2014. And we tried to fix a well that was there that we couldn't. And we referenced 2017, but then we drilled a well that was dry. And all of this was around trying to reduce the cost to the University of Wyoming because they was paying for potable water. And at one time, we heard from the city, it doesn't make sense to pay for, why are we using all this potable water in the strain on the water system for irrigation? And so then we switch over here. And so I think the discussion has gone on. And so my question then is how long do we need to go on before we say we need to do something here?
Go ahead.
Thank you, Mr. Chairman, through the chair, Representative. You know, obviously this discussion's been going on longer than my tenure, as you point out. I will say that, you know, the university and the city are dependent on each other. The university, you know, chooses to locate in a city for a reason. It, you know, it's students, it's faculty, it's staff. You know, it relies on not only the infrastructure, but the other things that are available in a city. And I just think that there's such a reliance that they have on each other. I do believe, especially if I do believe that the city is still invested in finding a solution to this. You do make a valid point that you know, using potable water on grass is not the best use of potable water. So finding a non-potable source for that is good. However, you know, you can't really say the university, and I recognize the unpopularity of what I'm saying, but you can't really put the university on an island, as it were, even if it were just in this non-potable water. As Ms. Jordan, the city manager, points out, the water system and the wastewater system and the stormwater system are all interconnected. And the city, at the very least, if the university were to proceed with this, a well for non-potable watering of this facility, it would certainly need to be done, not unilaterally, but done in concert with the city to make sure that the runoff from that was properly handled, and that it didn't put stresses on the city's infrastructure, or whether those be fiscal stresses from existing investments and bonds and so forth, as well as the changes it may make in the fiscal. For example, I'm
going to have to cut you off. We're about done with time, but I think we understand your position. You got any other particular points you want to make? Because we're already late. So.
No, I was going to, which I'll withhold. I was going to give some examples of how it could negatively impact the actual infrastructure of the city's water system, but I'll concede the mic.
Any other final comments, Mr. Crank?
I would just, Mr. Chairman, I just tell the committee that we've had extensive talks with the city and cannot resolve the passage of this ordinance. In fact, the governor directed the attorney general to hold a mediation, and we spent a day talking about these issues to no success. Thank you.
So, Mr. Crank, is it fair to say if this bill does not pass, then the next step would be litigation?
I believe so. We will begin building the infrastructure from the wells to Jacoby, and the city will likely sue under their ordinance. So there'll be litigation without this ordinance.
Okay, any further questions? With that, we will close public comment. Motion on the bill. Moved by Representative Walters, seconded by Representative Larson. Representative Stiff.
Mr. Chairman, I would move to strike the words potable or on line 2, page 2.
We have moved and seconded to strike the word potable or. All those in favor say aye.
Aye.
All those opposed? That motion carries. Any further motions? Question being called. Roll call.
Representative Kinner.
Aye.
Representative Larson.
Aye.
Representative Schwartz. Representative Simpson.
Aye.
Representative Stiff.
Aye.
Representative Walters. Chairman Nicholas.
Aye.
6 aye, 1 no.
All right, thank you, folks. We'll be off and running.